Welcome back to Firepower. Sometimes history doesn't change with a bang. Sometimes it changes with a sentence, not a law, not a vote, just a few words written quietly inside a court filing. And yet, those words can shake an entire industry overnight. That is exactly what happened recently, when gun sales across the country surged at levels we haven't seen in years. Shelves emptied. Websites crashed, ATF forms slowed to a crawl. And the reason wasn't a new ban, or a new regulation, or even a final Supreme Court ruling. It was a single legal admission made by the Department of Justice that many people are still struggling to fully understand. Today, we're going to break down what actually happened, why that one statement mattered so much, and why gun owners reacted immediately. This isn't hype. It's not panic. It's a shift in the legal landscape that has been building for years, and it may end up changing how firearms, suppressors, and gun rights are treated in the United States for decades to come. Let's start with the moment that triggered everything. In a legal brief filed in the case Vanderstock vs. Garland, the Department of Justice made a statement it had avoided for generations. In plain language, the DOJ acknowledged that a suppressor is an arm within the meaning of the Second Amendment. That sentence alone sent shockwaves through the firearms community. Not because it was shouted from a podium, but because it was written into an official federal court filing. For decades, suppressors have lived in a strange legal category. They were treated as dangerous accessories rather than firearms themselves. That distinction is what justified their inclusion under the National Firearms Act of 1934, complete with tax stamps, long wait times, and heavy restrictions. The government's position was always clear. Suppressors were not protected arms. They were regulated add-ons. And then, suddenly, that position cracked. The DOJ did not make this admission because it wanted to. It made it because it was cornered by modern constitutional standards. After the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen, the rules changed. Under Bruen, the government can no longer defend gun laws using vague claims about public safety. It must show a clear historical tradition of regulation dating back to the founding era. That's where suppressors became a problem for the government. There is no historical tradition of banning or heavily regulating suppressors in 1791. In fact, suppressors didn't even exist in their modern form until the early 20th century. The NFA was not based on constitutional analysis. It was a political response to crime and poaching during the Great Depression. Once Bruen forced courts to demand historical justification, suppressor restrictions suddenly stood on very shaky ground. The DOJ had two choices: deny reality and risk losing badly in court, or concede a key point and try to control the damage. It chose the second option. By admitting suppressors are arms, the DOJ attempted to preserve some regulatory authority while acknowledging constitutional reality. But that admission came at a cost. Once suppressors are acknowledged as arms, they fall under the same constitutional umbrella as firearms themselves. That changes everything. It means restrictions on suppressors must now survive the same level of scrutiny as restrictions on guns. It means bans, taxes, delays, and outright prohibitions are no longer insulated from serious constitutional challenge. Gun owners understood that immediately. Within hours of the DOJ filing becoming public, suppressor sales spiked dramatically. Major retailers reported increases of several 100% in suppressor-related purchases. Not just suppressors themselves, but threaded barrels, subsonic ammunition, and integrally suppressed firearms. ATF Form 4 submissions flooded the system so quickly that processing delays became obvious almost overnight. This wasn't fear buying. It wasn't panic over an impending ban. It was opportunity buying. Gun owners recognized that this admission marked a turning point, not a final victory, but a crack in a wall that had stood for nearly a century. Many buyers believed, correctly or not, that suppressors may never be treated the same way again. And when people believe the rules are about to change in their favor, they act. What's even more interesting is who was buying. This surge was not driven solely by collectors or hardcore NFA enthusiasts. A significant portion of buyers were first-time suppressor purchasers, families concerned about hearing protection, hunters looking to reduce recoil and noise, shooters who had avoided suppressors for years because the legal process felt unjustified or intimidating. Suppressors began to be viewed not as exotic tactical equipment, but as practical safety tools, hearing protection, courtesy to neighbors, reduced recoil, improved shooting experience. In many ways, suppressors were being reframed as the seatbelts of the firearms world. Not about aggression, but about responsibility. That change in perception matters just as much as the legal shift. The ripple effects didn't stop at consumer behavior. The DOJ's admission is now being used as ammunition in courtrooms across the country. States that maintain outright suppressor bans, such as New Jersey, Massachusetts, New York, and Illinois, are facing renewed legal challenges. Plaintiffs are no longer arguing theory. They are quoting the federal government's own words. That creates a serious problem for state attorneys. When the federal government itself acknowledges suppressors as protected arms, defending state-level bans becomes far more difficult. The argument that suppressors are dangerous accessories collapses when the DOJ has already conceded their constitutional status. This does not mean those bans disappear tomorrow. Legal battles take time. Appeals will be filed. Judges will disagree. But the direction of travel has changed, and courts pay attention to that. There is another layer to this story that often gets overlooked. This case didn't happen in isolation. It followed closely on the heels of other major defeats for regulatory overreach, including the collapse of the ATF's frames and receivers rule. In that case, courts ruled that the ATF had exceeded its authority by redefining unfinished parts as firearms. The message was clear. Agencies cannot rewrite laws simply because they want more control. Suppressors are now part of that same pattern. Courts are increasingly unwilling to let executive agencies expand definitions without explicit congressional authorization and constitutional support. That trend should concern regulators and encourage citizens who care about limits on government power. At the same time, it's critical to understand what this moment does not mean. The National Firearms Act has not been repealed. Tax stamps are still required. Wait times still exist. Many states still prohibit suppressors entirely. Buying a suppressor today still requires compliance with all existing laws. Acting as if suppressors are suddenly unregulated would be a serious mistake. This admission opened a door. It did not tear down the building. Legal change happens slowly, unevenly, and often frustratingly. Some courts will move faster than others. Some states will resist more aggressively. Some victories will be partial. Others may be temporary. Anyone telling you that suppressors are fully free tomorrow is either misinformed or dishonest. So why does this moment matter so much? Because it represents a shift in how the government talks about the Second Amendment. For years, the strategy was denial. Avoid acknowledging constitutional protection whenever possible. Treat firearms as a regulated privilege rather than a protected right. That strategy is becoming harder to maintain under modern constitutional scrutiny. Once the government admits something is protected, even reluctantly, it changes how every future argument must be framed. It raises the cost of restriction, it invites challenge, it empowers litigation, and it signals to citizens that long-standing assumptions may no longer hold. That is why gun sales surged, not because people were scared, but because they sensed momentum. Momentum matters in law. Momentum shapes markets. Momentum changes behavior. For gun owners, the lesson here is not to celebrate prematurely or ignore existing rules. The lesson is to stay informed, understand the difference between a legal argument and a final ruling, and recognize that constitutional battles are marathons, not sprints. If you are considering a suppressor, this moment explains why so many people suddenly are. If you are not, it still matters, because it reflects a broader shift in how rights are being interpreted and defended. The most important thing to remember is this: rights are not static. They expand and contract through pressure, precedent, and persistence. The December filing didn't finish the fight over suppressors. It changed the terrain, and when terrain changes, everyone moves. Now we want to hear from you. Did this legal admission change how you view suppressors? Do you think they should be treated like standard firearms, or do you believe additional regulation is justified? And do you think this moment represents a true turning point, or just another chapter in a long legal struggle? Leave your thoughts in the comments. These discussions help people cut through noise and understand what actually matters. If you want more clear, grounded analysis without panic or exaggeration, make sure you're subscribed to Firepower. We focus on what's real, what's changing, and why it matters. Stay informed, stay responsible, and we'll see you in the next one.